your assets are vulnerable. Corporations start up all the time, corporations go under. You read in the paper all day long about startup companies that do well, some don't do so well. 9 out of 10 small businesses fail, something goes wrong. So at least protect yourself, or just your limited investment capital is all that's vulnerable to bankruptcy or to problem situations. Let's talk about multiple businesses. We see a lot of situations where people own, for example, a chain of restaurants, and all it takes is one problem within one restaurant, the whole structure collapses. Everything gets forced into bankruptcy. If you have separate businesses, each one should be a separate corporation. And actually, within some businesses, we even designate divisions. For example, if you do manufacturing, let's set up a manufacturing corporation. If you're doing sales, sales corporation. If you're doing international business, we set up an international corporation to handle that part of it. So everything should be done through separate corporations to the extent possible to minimize the risk of forfeiture of the corporate assets. And we can also set up situations where physical, tangible assets are in one company. For example, a Nevada company, that can hold physical, tangible assets. That can hold real estate, perhaps vehicles, equipment, all the tangible assets that make up the corporation. What we put through the corporation, the one that does business with the public, is just income. Income coming in, income going out. It doesn't have any real tangible asset base. Now, we get use of those assets through lease agreements. So we have all the assets held in Nevada, we lease them to the California corporation. The California corporation does the active business. The active business is the one that's vulnerable to lawsuit. So if they sue, we'll let them go after the business that's active, right? What are they going to get? Nothing, because there's no assets within the corporation, only income. That corporation could be folded, new one started up. So that's one of our basic asset protection tools, is multiple corporations. And the same thing we can do with the LLC. We can set up LLC structures, children's trusts, living trusts, everything but the active corporation should hold the physical, tangible assets. Okay. Now let's talk about, on asset protection, a few other strategies too. Well, one thing we should talk about that's very important is when to do the asset protection. I consider asset protection, particularly the lawsuit protection attributes, and that part of the asset protection plan, to be something you have to do before it's really needed, because there's a concept of fraudulent conveyance. That means if you convey any asset during your lifetime for the purpose of avoiding a creditor, it could be considered fraudulent. The courts have interpreted any kind of transfers or any kind of method to diminish the ability of creditors to attach your assets to be a badge of fraud. So it really is more or less based on intent. So if you're notified of a lawsuit, immediately you transfer all your assets to your brother-in-law, well, that could be an obvious case of fraudulent conveyance. That was exactly your intent, right? I've seen clients do that. They get a big lawsuit, transfer everything to their children, and go out and file bankruptcy and hope you don't get caught, for bankruptcy fraud and for outright fraud against the creditors. Very poor planning. What you need to do is set up the structure before it's needed. If you have no lawsuits right now and no creditors that have an immediate target against you, we feel comfortable conveying these assets because it has so much of an attribute of estate planning. Everything that you transfer is for the purpose of estate planning. So it goes into corporations, limited liability companies, limited partnerships. All these various structures are going to hold the assets, but our conveyance into them is for the purpose of protecting children, protecting grandchildren, tax advantages, everything that gets involved with setting up business structures. But a byproduct of that is the asset protection. But that's not our main, it may be our intent, but it's not our intent that we're going to state to the world. To the world, we say we did proper estate planning. We came to a seminar, we learned about estate planning, we set up limited partnerships, we set up corporations, we set it up for tax structure, we set it up for prudent business structure, we set it up for estate planning. Well, a byproduct of that is the asset protection. So a year or two later, you get a lawsuit, it's going to be very, very powerful to have that structure in place to defend. What I don't want to have happen is the client comes to us after they're sued or right before they're being sued, and they know it's coming, right? Because the first thing they want to do is move the asset. Well, that's where we get involved with fraudulent conveyance. And the penalties there could be civil, could be criminal. Typically civil to the extent of triple damages, and also loss of the protection, because all the structures that we set up, the court could try to unravel that. And we don't want to give him any ammunition. We don't want to give him a structure that was set up late in time, after a lawsuit was filed. It's going to be obvious to everybody what happened. So it's a little bit like the flu. When you have the flu, you need the flu vaccine. What does the doctor say? Come in before you get the flu. After you get the flu, you get the flu vaccine. It doesn't work. It has to be done early on. It's almost like it grows with time. It's sort of, the asset protection plan ages like wine. It just builds upon itself. Just imagine today you're served with a lawsuit. Had you done planning 5 years ago, 10 years ago, 15 years ago? How would they argue fraudulent intent? How could you be intending 10 years ago to set up something with the anticipation of a lawsuit 10 years from now? It's pretty remote. Remote in time and remote in intent. So as much as we do, we set up estate planning attributes. Now, if there is a lawsuit, well, so be it. All the assets are within the structure. And if they want to pursue that, they can pursue the assets that we left outside the structure. But what happens typically is any type of lawsuits are very time-consuming and very expensive, even for plaintiffs. If we can give them a notion that you don't have any assets, it leaves it ripe for settlement. And a lot of lawsuits these days are settled before they even go to trial. So what we do is, well, our first line of defense is, or avoiding the lawsuit in the first place, is low profile. We want to keep yourself in a low profile situation, anonymity, privacy. That means all the assets we titled through the asset protection plan in limited liability companies, trusts, limited partnerships, whatever we did, are in generic anonymous names. That means that plaintiff attorney, before he even files that lawsuit, he's going to meet with his plaintiff client. He's going to be thinking about legal fees, right? Attorneys don't work for free. They're going to probably take that case on contingency. The plaintiff, they usually don't want to pay things hourly billing because they don't know what they're going to get. And the attorney, he's going to want to, if he takes on contingency, he's going to want to do some preliminary research. He wants to research what type of assets does that defendant have. Now, if you get in a car accident and the person that you had the accident with is not in the country legally, they have an old beat-up car, and they have no insurance, you know what you're going to do. You're going to go back to your own insurance company and pursue that. You're not going to bother with any lawsuit. But if that person that you had the auto accident with happens to be chief of neurosurgery at UCLA Medical Center, and they drive a nice Mercedes and they live in the most expensive part of Malibu, well, you think, my gosh, you know, you have a few more extensive soft tissue injuries, and now you're going to pursue legal action on a contingency basis because there's something to go after. The same approach. If we keep you low profile, no public record, that plaintiff attorney, when they meet with their client and say, well, let me see if I'll take that case or not, I'll get back to you. Well, they're going to run out and do what's called a public record search. They're going to search the public record looking for real estate, looking for tangible assets, physical assets. They might even search for bank accounts. If there are none, they're going to go back and say, well, what do you mean we're going to take this on contingency? I get 30%, 30% of zero is zero. What are we going to do? We're going to work hourly billing. Give us a retainer. Well, the plaintiff might get scared right then and there. You know, have to spend real money pursuing a lawsuit? No, not what they want. So what do they do? Even if they file the lawsuit, we can go into them at that time and explain to them that there are no assets available for this type of lawsuit. What I sometimes like to do is designate a specific amount of money. Say we set aside $50,000, and we set it aside in an account, and I call it almost like a self-cannibalizing account because we expend that money for defense of that lawsuit. As we spend it, there's less and less money. So we tell the plaintiff, we said, look, we put aside for you $50,000. If you take it right now, you get $50,000. If you wait a year, there's going to be $20,000 in that account because we spent $30,000 on legal fees. If you wait till the end of the lawsuit, there'll be zero. That's all you're going to get. Take the $50,000 right now. So you can see how powerful that is. The attorney's going to look at what's 30% of $50,000. I get $15,000 to do nothing, right? Sell the case right now. If I wait till the end, it's zero. 30% of zero is zero. Well, tell you what, he's going to go in and convince his own client to settle. So here you have the opposing party's attorney arguing your case for you. He's going to go to his own client and say, do you want that guy that we're suing? Let's take whatever he's got. You know, $50,000 right now. Let's get out of this mess. We don't want to take this to the end of the trial. What a nightmare for them, right? 2 years of litigation and get nothing. So we're almost proactive. We tell the plaintiff attorney we have no assets. It works beautifully. I'm going to be talking now about the most exciting topic of asset protection. That's the offshore asset protection. And I know it sounds a little bit exotic, offshore, but let's talk first about banking. In the United States, we have what's called the Bank Secrecy Act, and it's really nothing but anything about bank secrecy. An example is just to access now merchant services through a bank, you can get all the information you need about people's checking account just by knowing their